Thanks so much. My name is Jerry Mattman, and I'm pleased to be one of the presenters at today's webinar. I'd like to introduce my partner, Colin. He is a member of the trial group in our Philadelphia headquarters office. He's got a deep skill set in the privacy area and class action work in particular. He's got a nationwide practice in terms of handling these sorts of cases throughout the United States from coast to coast. And he's a leading thought leader in this space in terms of his writing and presentations and webinars that he's presented to audiences. So it's our pleasure to have Colin with us today.
Thank you, Jerry. It's a pleasure to be here today. I would like to introduce Jen Riley. Jen is a partner in our Chicago and New York offices and is vice chair of the firm's class action defense group. Jen has been defending some of the largest class actions filed across the country for more than 2 decades. She regularly develops strategies for navigating some of the largest challenges faced by corporate America today. Among her cases, she has handled several of the largest class actions ever filed in California, Illinois, Tennessee, and New York. She was selected this past year by J.D. Supra as one of the top 10 thought leaders in the U.S. on class action litigation, and her articles and writings on class action have appeared in numerous prominent publications and forums such as Law 360 and Bloomberg News.
Thanks so much, Colin. It's a pleasure to be here. And it is my great honor to introduce Jerry Mattman. Jerry is a partner in the Chicago and the New York offices of Duane Morris, and he chairs the firm's class action defense group. Jerry has been confronting and defending the largest and most complex class actions across the country for more than 4 decades. Jerry's past year was highlighted by a number of precedent-setting victories in substantial class actions across the U.S. Those range from outright dismissals to persuasive arguments in federal appellate courts to the dismantling of massive class and collective action cases. This past year, Law 360 named Jerry as an employment law MVP. That's an award that recognizes the top 5 attorneys in the U.S. for each respective area of law. And it turns on input not only from clients and colleagues, but also from litigation opponents. And it distinguishes Jerry as one of the top 5 employment lawyers in the United States. With this year's honor, Jerry has won the MVP for 8 out of the last 10 years, more than any other lawyer in the country. Additionally, Chambers recognized Jerry's work in its 2022 global rankings and stated, Mr. Mattman is absolutely phenomenal, as he is one of the top class action minds in the country. Jerry, it's a pleasure to have you on the panel today.
Well, thanks so much. Colin, Jen, and I put together an agenda that would give you a tour of the privacy world and what's going on throughout the United States in terms of cases being brought, attorneys' demand letters, and things that corporations need to take heed of in terms of their compliance activities. So the agenda divided this into 4 areas to talk about the key laws that impact corporate America and what the trends are in terms of the interpretation of those laws. What's going on in the courthouse in terms of the types of cases being brought and the settlements that are spiking out of those cases. The third would be what are the key landmark rulings in this area as the case law evolves. And then lastly, what we see on the horizon and what we like to say, what ought to be in your toolkit to get ahead of these problems in terms of compliance issues and activities. So first, we'll start with the key statutes and the key trends. In this particular area, we put together a map, and what you'll see here is this is a patchwork quilt. There's no federal law. Instead, there are regulations both at the state level and at the city or local level that impact privacy obligations of companies or provide privacy rights to employees, consumers, anyone who would interact with, for instance, a website or digital technology of a company. And so what this means is compliance is obviously more difficult because of this patchwork quilt. And then the other complicating factor is these changes are happening very rapidly and are evolving. And so one of the things we like to see at a company And when we're working with an HR department or a corporate legal team, is a designated individual inside the company in charge of privacy and in charge of tracking and updating this patchwork quilt. In essence, a privacy officer. This acts in a great fashion to help companies get ahead of the curve. Um, Here is a listing on this particular slide of what are the key laws out there. And the Illinois Biometric Information Privacy Act is kind of the granddaddy of them all. And that's the one that has spiked the most litigation. And just like California tends to be in the wage and hour class action area, Illinois has been a leader in the class action area in privacy litigation. And as a result, many of the other states and localities that have put together statutes have modeled it on the Illinois statute, which goes by the acronym BIPA. Probably the first and the most famous that mimicked the BIPA statute was in Texas. But the big difference there is there's no private right of action like there is in Illinois. In Texas, those cases are brought by the Attorney General, but there have been some significant and very large cases that have resulted in massive settlements brought by the Texas Attorney General. The New York City biometric law was the first statute where a significant locality or city put teeth in privacy protections. And Colorado is the latest law signed by a state taking its place in line last month, and in many respects is probably one of the most expansive, if not forward-looking pieces of legislation out there. And then under that, you'll see there are significant states that are right now debating and thinking about proposed legislation, and that list grows by the month. If we took a snapshot of this patchwork quilt probably 12 months from now, my sense would be that the list is going to be much longer and there'll be more states that'll be on the list. So one thing that you can learn is kind of what happened in Illinois and the model that other states and localities are looking at. And so basically what the BIPA statute does is it is very expansive in terms of regulating anyone who collects, uses, handles, stores, biometric identifiers, information used to identify people that involves thumbprints, retinal scans, facial geometry, all sorts of biometric information. And to date, there have been over 5,000 class actions brought against Illinois companies for alleged violations of the BIPA. We'll talk about that a little bit more. One of the main exemptions from the Illinois BIPA is a financial institution. Illinois being somewhat of a worker-friendly or consumer-friendly state, by and large, that sort of exemption has been construed narrowly. There is also an exemption for governmental contractors, but that likewise has been construed narrowly. So if I gave you a test and said, what did these people or what did these entities have in common, the list would be kiosks at the O'Hare International Airport, the gate at a used car lot, the operator of a home security system, and an employer that uses software to do video interviews. Those four entities, those four concepts have all spiked BIPA litigation, where there is an allegation that fast food restaurants at the airport, in terms of taking voice prints of customers that are ordering during a kiosk for food, a used car lot that uses a biometric thumbprint system to allow people taking a test drive of the used cars to go in and out of the lot, DoorDash drivers who have sued home security systems for taking face prints and geometric scans of their face and then video interviews aided by artificial intelligence that conducts interviews of candidates via the internet. These are all situations that have involved BIPA class actions invoking this statute. So as you can see, very, very broad. Jen, what are some of the current states of this sort of law and this sort of litigation?
Thanks, Jerry. So in terms of lawsuit filings, for nearly a decade following the enactment of BIPA, activity under the statute was largely dormant. We saw an average of about 2 lawsuits per year from about 2008 to about 2016. Following that, though, in 2017 and 2018, those numbers grew exponentially. In 2022, companies saw more than 5 times as many class action filings for alleged violations of BIPA than they saw in 2018, and more than the number of class action lawsuits that they saw from 2008 to 2018 combined. So, as Jerry mentioned, other states have taken steps to consider similar statutes. Thus, Illinois presents somewhat of a test case or a crystal ball, if you will, as to what could happen if other states succeed in enacting similar statutes with a private right of action. Businesses then could expect similar surges in terms of the filing numbers and growth as Illinois continues its upward trend. So at this point, we're looking at second generation BIPA cases. So the plaintiff's class action bar is ever creative in continuing to look for ways to take advantage of the BIPA's technical requirements, its stiff statutory penalties, its fee shifting provisions. And we're seeing the bulk of activity today extend beyond mere biometric time clocks and mere fingerprint scans that inspired that first wave of BIPA lawsuits. The plaintiff's class action bar is bringing suits that challenge an ever evolving slew of different technologies. We're seeing target technologies, as Jerry mentioned, such as voice recognition software, surveillance systems, and virtual try-on technologies that are available through certain websites and certain apps. Now let's talk about wiretapping. So class action litigation in the privacy space has continued to generate a multitude of filings, and many of those filings can be characterized under this label wiretapping. Plaintiffs are bringing a huge number of class actions under state wiretapping laws, under state anti-surveillance laws. Many of these claims have been grounded in the electronic interception provisions of wiretap statutes like the California Invasion of Privacy Act, the Pennsylvania Wiretapping and Electronic Surveillance Act, the Florida Security of Communications Act, among other laws. These together generally prohibit unauthorized interception of electronic communications. So plaintiffs have initiated these class actions against companies that use third-party software to track activity on web pages, as well as against companies that create and record transcripts of conversations conducted via website chat features. These are based on the theory that such practices violate these electronic interception provisions of various state laws. Many of these state laws, of course, were enacted at a time before many of the drafters really could have envisioned or anticipated such technology. So in other words, the plaintiffs are repurposing some of these old laws and applying them to these new technologies. Colin, do you want to talk about session replay software in particular?
Sure. Thanks, Jen. If you could go to the next slide, please. Oh, go back one, I think. So I'm going to talk a little about the technologies that are being really targeted with the wiretap statutes. And as Jen just mentioned, these really are mostly old Cold War era statutes that were designed for anti-espionage really before, well, not really before, well before computers were even a thing, or the internet. So we were talking about rotary phones essentially. And we have these plaintiffs' lawyers now trying to shoehorn these new technologies into these laws. So session replay, as Jen mentioned, what that really does and some of our attendees may be aware of this, many probably aren't because it's usually left to the marketing people. That will record what a user who visits a website, how they navigate the site. So what they hover over, what they click on. And in that regard, it's very similar to sort of watching somebody, if they're in a retail store, just walk around the store and view what they're doing, what they're looking at, what their preferences are, or even be recorded by security cameras when they're doing that. But the allegation here is that the website is doing this without the user's consent. Session replay technology, I think, was really targeted in a way that we saw a couple of years ago. And it's sort of fallen out of favor a little bit with the plaintiff's bar, as often happens with these cases, because they're getting some unfavorable decisions, which we'll talk about a little bit later. And part of that, I think, ties in with their struggle to allege that there's any actual content that's being collected or stored. It's really whether there's any personally identifiable information as opposed to just record information of how the user navigated the site. Could you go to the next slide, please? So if you could go back one slide, I apologize. And we talked a little bit about the chat bot and chat features. After the session replays, cases sort of started to die down. We saw a lot of those cases pop up. They've also really sort of fallen by the wayside in the past several months, although we're still seeing them as the plaintiff's lawyers try to plead around some of the issues that have been identified in the court orders. But in these cases, really what the allegation is, as Jen mentioned, is that users are accessing the chat feature, which is usually operated by a software as a service provider, so a third party, and then that's being stored on their server and intercepted in real time. And it's, again, all being done without their consent. And just a quick word I wanted to mention about consent. Most websites where they ran into problems with the chat feature have what's called a browse wrap. So the privacy policy is in a hyperlink at the bottom of the home page, as opposed to, and there's really no assent to it. There's no affirmative assent by the user, as opposed to a click wrap where you're actually having to click that you agree to the privacy policy. So one of the reasons I think that some of these cases have gone away is as the lawsuits were filed, both the software as a service providers and the websites started adding into their chat an actual click wrap where you had to click to agree to move forward with the chat and the privacy policy, which made it much more difficult to bring those cases. Okay, if you go to the next slide, please. And then we come to the Video Privacy Protection Act. Again, this is another old law. This is a 1998 law that was designed to prevent the wrongful disclosure of videotape sales. It was actually enacted in response to Judge Bork. A local newspaper in DC got a hold of his list of movies he had watched and published it. There was nothing salacious, but it triggered Congress to enact a law in response to it. And I think it's fair to say that plaintiffs have had most of their success in these cases against video streaming services, but that hasn't stopped them from targeting really any website with a video embedded on it. And the gist of the allegations is essentially that if you watch a video, that information is shared usually with Facebook via Metapixel, and then Facebook uses it to retarget or bombard you with ads. So the very first case I saw, a VPPA case that I came across, was against a diet and weight loss company that the plaintiff alleged they watched a video, they got on Facebook, and all of a sudden every ad was weight loss and diet related. Again, we're seeing a lot less of these cases mostly because of unfavorable decisions, which we'll talk about a little bit later. And then if you could move to the next slide. So this is where I think in the data privacy, we are seeing the biggest uptick in claims. It started with session replay, chat features, the videos, and now it's really most of the lawsuits are just focused on the pixels. So the web pixel is just a little piece of code that's on the web page that collects information about a visitor's interaction with the page. And it's usually used just by marketing people to improve marketing efforts. And I can tell you now, having been on many, many calls with clients, usually the in-house counsel don't know what a pixel is and don't know what they're using. So one of the first things we'll do is get their IT people and their marketing people on a call and kind of go over what they do. And from a marketing perspective, this is extremely valuable to most companies. So valuable that they usually don't even want to part with it, even with the risk of the class actions that's out there. Just a little bit of a nuance. I don't want to get too in the weeds on the technology, but people, I think, confuse pixels and cookies a lot. Pixels are stored on the users, are not stored on the device. They're embedded in the web content, unlike cookies, which are on the device. So pixels can't be controlled by a user. We've seen a lot of these cases now, I would say more than dozens. We're seeing a lot of arbitrations to a lot of class actions. The allegations they've been using it to track the consumer-facing sites and the user's use of the site. And one of the problems that, I don't know if it's a problem, but one of the reasons I think the plaintiffs have sort of gravitated towards this, and what you see in all the complaints, is the idea that unlike a cookie, which you can control, the pixel starts firing and collecting user information within milliseconds. So as soon as you get on a website, it's collecting data. And the argument is you can have a click wrap, a scroll wrap, you can throw the policy, privacy policy right in a user's face. Even then, they still don't have time to read it before the website and the pixel starts collecting data. Again, these are usually typically being brought under state wiretap acts. And that's.
So thanks, Colin. So our next would
sorry.
be to analyze kind of the state of the litigation and what we're seeing out there in the courthouses. So the data that we're going to talk about is something that we collect on a daily basis. Here at Duane Morris, we prepare an annual study of class action litigations in all areas of law that companies deal with, one of which involves privacy. And every morning we download and put into a database records of all class actions filed in federal and state courts throughout the United States, as well as any and all rulings involving those class actions. And we put them in the database, and then we run the numbers, so to speak, come up with trends. And we also track and follow the settlements, and we're going to show you kind of what these trends and analyses show in terms of how they're telling for corporations in terms of what you're dealing with. So the first thing would be settlements. And what we've looked at are the top 10 settlements in this privacy area. These are the types of settlements that news conferences are brought about, that appear in TV reports, that appear on people's iPhones, where plaintiffs' lawyers or government enforcement lawyers are calling press conferences and touting what they've done. And last year, the top 10 privacy settlements topped $1 billion for the first time in the history of American jurisprudence. By way of example, the prior high year was just the year before in 2022, just short of $900 million. And the bar graph shows you kind of all of these settlements and what they've done. So we've tracked it in the first 4 months of calendar year 2024, and only the top 5 thus far were off to a roaring start at more than $250 million. And typically, most of the settlements occur in the third and fourth quarters of a calendar year. So we're probably going to see a settlement or settlement numbers that reach in this area and approach what went on last year. So what this says and what this manifests is privacy litigation is a white hot area. This is an area where the plaintiff's bar is attracted to these sorts of theories that Colin was talking about. And as you notice, they're kind of going from theory to theory or types of case to type of case in terms of the clusters of case theories that they're bringing. And the business model of the plaintiff's class action bar is file the case, certify the case, and then monetize the case. So obviously, class certification is the holy grail when it comes to privacy class action litigation. And what these numbers show is obviously an upward arc in the value of these settlements. So what's going on is that privacy litigation is attracting the best and the brightest from the plaintiff's bar. They're moving into this space because there's money to be made. So what we're seeing is the quality of representation on the plaintiff's side every year, every month is getting better than it was the preceding month because you have very skilled plaintiff's lawyers moving into this area. So we talked about BIPA and how BIPA was the engine that kind of started this area. And if you just took a snapshot at BIPA settlements, this is what you saw in 2023. The top 10 settlements were close to 150 million. That was actually down from calendar year 2022, where they were more than double that. And kind of the big difference was in 2022, there was a big settlement with McDonald's involving $92 million that kind of topped the charts. And a few years before that, that kind of the biggest BIPA settlement of all time was the Facebook settlement, $650 million. And virtually every citizen of the state of Illinois got a check from Facebook in terms of every Facebook user getting a settlement. And that kind of put BIPA class actions on the map, and it was no longer a sleepy statute that no one had heard about. If you stop citizens on the street in Chicago, the majority of them would know what you're talking about if you mention the acronym BIPA. And what Jen is going to talk about are some legal developments before the Illinois Supreme Court in valuing BIPA and how class action settlements occur, and what has occurred since those decisions in 2023 is a slowdown in settlements because the value of a BIPA claim actually went up as a result of those settlements. So you have the plaintiff's bar even angling for higher settlements, defendants being very resistant to it and beginning to try these cases and awaiting appellate court decisions as to the measure or value of these cases. And lastly, we'll talk a little bit about data breach, a subspecies in this area. And of all the white hot areas of privacy law, data breach probably the most white and the hottest of all the areas. They used to teach in law school that after a statement is issued by a corporation and there's any issue about that statement and the stock drops, inevitably there would be a securities fraud class action that would follow on that statement. Well, now the same is true when there's a cyber incident and a breach of privacy at a company. Inevitably a data breach class action will follow. And this was the highest ranking growth area in the filing of class actions last year. Just an explosion of data breach class actions, over 1,320 5 class actions brought in this space. And here the class action settlements top for the first time, $500 million. So kind of any way you look at it, when you measure what's going on by the value of the settlements, and especially those top 10 settlements in this area, you have kind of a perfect storm where there are new laws being passed. Compliance efforts are difficult because of the patchwork quilt of those laws, where you have high value settlements that are appearing in the headlines. You have skilled plaintiffs lawyers moving into the area. It all makes for a situation where corporations need to be aware and tread carefully in this area because the plaintiffs bar is looking to bring cases.
Let's talk more about the data breach class action filing. So as Jerry mentioned, the volume of data breach class actions really exploded in 2023. As a result, data breach has really emerged as one of the fastest growing areas in class action litigation. Now, after every major and, well, probably not so major report of a data breach, companies are seeing the resulting negative publicity along with one or more class actions. So as companies fall victim to data breaches, essentially they're facing class action lawsuits, including copycat lawsuits, follow-on lawsuits across multiple jurisdictions. And they're seeing that at an increasing rate. As this slide shows, in 2023, we saw a notable increase in data breach class action filings as compared to 2022. Plaintiffs filed as many data breach class actions in the first half of 2023 as they filed during the entirety of 2022. These numbers are on a similar trend to date in 2024, as you can see from that, the furthest right bar on our graph here. So several factors are likely contributing to these data breach class actions. The shift to remote work, the rise of cloud-based storage, the escalation of cyber criminal activity. These things together are giving rise to more data breaches across industries and therefore more lawsuits following on from those breaches. The MOVEit data breach is a very notable example. In 2023, the Judicial Panel on Multi-District Litigation consolidated more than 100 class actions that were filed arising from a cyber attack on that file transfer software, MOVEit. Let's look at the next slide. So despite the large number of data breach class actions filed over the past few years and the giant settlement numbers that Jerry showed us, plaintiffs are actually succeeding on motions for class certification in the data breach space at a fairly low rate, relatively speaking. Courts have really delivered a mixed bag of results on motions for class certification in data breach cases. In 2023, courts granted certification in only 14% of cases, meaning that 14% of the motions for class certification that were ruled upon in 2023 were granted. So why? Well, the U.S. Supreme Court's 2021 decision in a case called TransUnion versus Ramirez probably explains some of these rulings. That case has really presented a fundamental threshold challenge for many data breach plaintiffs. The question really being whether the plaintiff can allege that he or she suffered a concrete injury sufficient to show standing to maintain a claim. Courts have reached some mixed results about what that threshold showing requires. Some courts have found that a third party's mere access to personal information and a supposed heightened risk of identity theft is insufficient, whereas others have found that the mere disclosure of private information or a loss of privacy is sufficiently concrete. So once a plaintiff clears that hurdle, if a plaintiff clears that hurdle, then at the class certification phase, there's a larger and more daunting obstacle. Because a court is really only allowed or able or empowered to award damages to a person who is injured, courts have disagreed over whether to certify a class. A plaintiff must demonstrate that every putative class member, in fact, has suffered harm. Or in other words, does a plaintiff have an obligation to demonstrate before a class can be certified that the plaintiff has excluded those individuals who are uninjured? So given the potency of the standing defense and given the open questions, I anticipate that standing is going to continue to occupy a center stage role in data breach litigation as we move through 2024 and into 2025. Now let's look at some of the significant rulings. I just talked about a few, but let's start with the Illinois Biometric Information Privacy Act, in particular, BIPA. So as Jerry mentioned earlier, two rulings from the Illinois Supreme Court from February 2023 have really had a profound impact on the BIPA landscape over the past year. On February 2 of last year, 2023, the Illinois Supreme Court clarified the length of the statute of limitations applicable to BIPA cases. In Timms versus Black Horse Carriers, the bottom case on the slide, the Illinois Supreme Court ruled that a 5-year statute of limitations applies to claims under BIPA. That ruling adds to the risks for employers in this space and companies who do business in Illinois as well in terms of their BIPA class action exposures. On February 17, 2023, the Illinois Supreme Court issued arguably an even more significant decision in Cothron versus White Castle. The Seventh Circuit had asked the Illinois Supreme Court to provide some clarification on the accrual of BIPA violations, specifically whether certain BIPA claims accrue only once upon an initial collection or disclosure of biometric information, or whether a claim accrues each time a company collects biometric information and discloses biometric information. The Illinois Supreme Court held that it's the latter, that a claim for damages may accrue under the BIPA each time an entity scans or transmits an individual's biometric identifier or biometric information. So that ruling has the potential to exponentially increase monetary damages in BIPA class actions, especially in the employment context where an employee might scan in and out of work multiple times per day over more than 200 workdays per year. On May 16 of this year, however, 2024, it bears noting that the Illinois General Assembly passed a bill to essentially undo Cothron. It provides that a private entity that collects or discloses a person's biometric identifier or biometric information multiple times has only committed a single violation for which the aggrieved person is entitled to at most one recovery. That, of course, is still a bill, however, and it awaits the governor's signature. And the governor in Illinois now has 60 days from May 16 in order to sign that bill. And so it remains to be seen whether that will be the law of the land for the remainder of 2024 and into 2025. Colin, do you want to talk about some key rulings in the wiretapping space?
Sure. There are a lot of rulings that have been coming out in this space, but the plaintiffs kind of start back a few years ago. And I think on this first slide, the takeaway from these cases is the key question in a lot of these in any wiretap cases, who is a party to the communication? Because under federal and some state wiretapping statutes, there's what's called a party exception. The party exception to a wiretap claim means that as an intended recipient of a communication, you can't be considered an eavesdropper or a wiretapper. And the expression you hear is you can't tap your own wires. So, for example, this exception has been read into the California Invasion of Privacy law and has been used by courts in numerous cases, which we'll talk a little bit about later, to reject website chat feature claims. So even though there's an exception and it's clear on the face of the statute, in application it's been a little more nuanced. And if we look at these two cases, we'll start with the Facebook case first. In Facebook, the Ninth Circuit held that Facebook's use of a plugin on third-party websites, which duplicated the message a user sends to a web page's server, it's called a GET request, and transmitted that information directly to Facebook server, that didn't make Facebook a party to a communication between the user and the website under the Federal Wiretap Act or SIPA. And I know there's a lot of, when you get in the weeds on this there really is a lot of IT sort of slanted language. So you have to learn what some of this stuff means, like GET request. But the gist of that is that the court held that there was Facebook, that didn't make Facebook a party to the communication. And then when you contrast that with the Third Circuit holding in Google, in the Google case, the court held that third-party advertisers' use of cookies to duplicate a user's GET request for the purpose of displaying targeted third-party ads on the web page did not violate the Wiretap Act because the communications occurred directly between the user and the third-party advertisers. So despite the incongruity in the rulings, the concept is clear that the Federal Wiretap Act and SIPA are not implicated when the party recording the communication is a direct participant in the underlying communication. If you could move to the next slide. So these are a couple other important decisions in the past couple of years. Javier really spurred a lot of litigation in California. In Javier, the plaintiff allegedly visited an insurance quoting website that used a third-party software to record the user's interactions with the website. And after filling out the insurance questionnaire, the plaintiff viewed a screen only after filling this out that said, view my quote button would constitute, clicking that would constitute an agreement to the assurance's privacy policy. And the Ninth Circuit held that because that request wasn't made until after the session replay software was run, the communication was recorded without valid consent. POPA is another recent case that's important, not just in the class action. And I know, Jerry, this is a class action CLE, but we're seeing a lot of arbitrations. I think some of these plaintiffs' lawyers, maybe the more trolling type lawyers, are kind of doing an end around and trying to go straight to arbitration. The implication being they're sort of threatening a mass arbitration by sending them multiple demand letters or filing multiple arbitration demands. And this ruling is important because the Third Circuit held that the location of the interception of the plaintiff's data is actually the plaintiff's browser, not where the signals are received at the Pixel servers. So, for example, we had, and again, I apologize for going outside the context of class action, but we had a client get several demand letters and actual filed arbitrations by a law firm in California alleging violations of the California Invasion of Privacy Act. Our client is located in Pennsylvania, has a Pennsylvania governing law clause. Obviously, if you're using the arbitration agreement, which is located in the terms of service, you've by implication agreed to the governing law clause. And so we were able to get that because the claimants are all in California. We've had success getting those arbitrations dismissed. So that's an important case to keep in mind. Next slide, please. So in terms of the Video Privacy Protection Act, there's a couple of cases here we'll talk about, but just out front, there are a lot of strong defenses to these cases, which is why I think we've seen a decline in them the last several months, even though we're still seeing some be filed. First, the VPPA defines a videotape service provider as anyone engaged in the business of affecting interstate or foreign commerce, of rental, sale, or delivery of pre-recorded video cassette tapes or similar audio-visual measures. And so one of the district courts has said, well, really the focus of the defendant's work has to be on videotape service providing, which most websites, I think we can safely say, are not. And the other focus in the two cases that we can see here and on the next slide is on the definition of a consumer. The VPPA defines this term as any renter, purchaser, or subscriber of goods or services from a video service tape provider. And the terms renter and purchaser are obviously straightforward, and typically a visitor of a website isn't renting or purchasing. Subscriber is where they usually go. It's not as clear, but most courts have agreed that merely accessing a website and watching a video doesn't make the user a subscriber. And as you can see in the Salazar case, if you go to the next slide, I know we're kind of bumping up against it, so I don't want to read through all these. Can you switch to the next slide, please? In both these cases, there's an allegation that the plaintiff was actually a subscriber, but really they were just receiving newsletters and emails and other things with links maybe to videos, but they weren't subscribing specifically to a video service. I have had plaintiffs' lawyers try to make novel arguments in these cases. We represent a large insurance company with sort of an iconic commercial character, and they tried to argue in the response to our motion to dismiss that that was sort of akin. People were actually going to this website solely to watch the commercials that they could see on TV, and that somehow made them a video provider, and the court didn't buy that argument at all. All right, if you go to the next slide, please. So in terms of the California Invasion of Privacy Act, initially, when we saw the real wave of this litigation in late 2022 and beginning of 2023, they were being filed all over California in state and federal courts. I think the plaintiffs' lawyers were really just sort of searching for the most favorable venue, and they got beat up pretty good in federal courts, who I think saw what was going on here and wanted to put an end to it. There's been several, and they continue to come. I had one granted a couple weeks ago, motions to dismiss, particularly in the chat box, chat feature cases. And there's a list here. I know we're kind of bumping up against the end here, and I want to move on, but I would just talk briefly. Lennox was actually my case in front of Judge Alsup in the Northern District of California. He was skeptical right from the jump of this case, telling the plaintiff in his order that the facts are bare in the pleading. And then from there, he proceeded to rule that there was a party exception because Lennox couldn't be held liable for eavesdropping on a conversation held in a chat feature that Lennox hosts on its own website. The plaintiff in that case also made the allegation that the communications were highly personal. And if you know anything about Lennox, they sell plates and tablecloths. So the judge also kind of thought that was a little bit ludicrous at the oral argument. And then secondly, the judge just sort of picked apart the conclusory allegations on the aiding and abetting claim that this was somehow the information of the chat that was being stored was being utilized and monetized by the third party that hosted the chat. And there was just no evidence of that. He did allow them a chance to amend, and they came up with a convoluted theory, which I think Jerry and Jen would agree is what we see in a lot of these cases. They start to try to plead around it and come up with new theories every day. And again, the judge wasn't buying it. He told them he was going to dismiss the case or issue an order dismissing it. They walked out of court, and within a half hour, they had filed their own dismissal of the case. So with that, I will pass it to Jerry to talk about some of the data breach key rules.
Yeah, Jen, I think this is your slot.
I think this one's
Oh,
fine.
Jen, I'm sorry.
Oh, that's okay. So let's talk about a few of the key rulings in the data breach space. The one I already mentioned, TransUnion versus Ramirez, has really been a game changer for defendants. You can see its impact in this case called Bonac versus Marcia McLennan. That's a case where Marcia McLennan suffered a data breach back in April 2021 that included social security numbers and other information belonging to current and former employees. The plaintiff brought suit there alleging, again, that this unauthorized third party had accessed her name, her social security number, and the district court said, yeah, that's not really enough for standing. A risk of future misuse of personal information, it doesn't really constitute a concrete injury. So that's consistent with rulings from other district courts. However, in this one, the Second Circuit reversed. It held that under TransUnion, disclosure of private information is sufficiently concrete for purposes of Article 3. And the fact that the plaintiff had alleged that she incurred out-of-pocket expenses associated with prevention, detection, recovery from identity theft, lost time, other opportunity costs, and things of that nature from attempting to mitigate the consequences of the data breach was sufficient for standing. In a different type of case, in re Blackbaud, this is an interesting one out of the District of South Carolina. This relates to a data breach that happened back in 2020. A cyber criminal breached the systems of the defendant, captured more than 90,000 backup files containing data belonging to about 13,000 customers, but also data belonging to approximately 1.5 billion individuals worldwide. In the ensuing lawsuit, the District of South Carolina actually then denied the plaintiff's motion for class certification. The court found that the plaintiffs had failed to meet their burden of proof as to ascertainability, and that they had failed to demonstrate any sort of administratively feasible method by which to identify the estimated 1.5 billion putative class members. Finally, the last case on the slide is a notable case to follow. I mentioned this one earlier. The MoveIt data breach is considered the largest hack of 2023. The breach allegedly exposed personally identifiable information of more than 55 million people. Affected entities include various household names: Shell, American Airlines, the U.S. Department of Energy, the government of Nova Scotia, along with various departments of motor vehicles. So that is a data breach litigation that certainly should be at the top of your watch list for 2024.
Jen, before we move on, it strikes me that one of the problems is plain old greed. And the larger that a plaintiff's lawyer makes the class and the more expansive it is, the easier it is for a company to pick it off and block class certification and vaporize the case. The decision out of South Carolina being a great example of beware of those who ask for too much.
Well said. Let's look at the a couple of key rulings from the Illinois Genetic Information Privacy Act space. So while the BIPA that we talked about earlier, the Biometric Privacy Act, so while that surge in class action lawsuits really has become part of the mainstream over the past few years, there is a similar Illinois statute that's starting to follow the same playbook and becoming an increasingly popular source of litigation. The Illinois legislature enacted the Genetic Information Privacy Act in 1998 in order to enhance privacy protections for people in Illinois by prohibiting the unauthorized disclosure and use of an individual's genetic information. So after 2 decades of this law pretty much flying under the radar, the Seventh Circuit affirmed a district court ruling in Bridges versus Blackstone that an individual need not allege an actual injury or adverse effect beyond mere violation of his or her rights under this law in order to qualify as an aggrieved person. So that ruling has opened the door for some plaintiffs to recover some significant damages, and as a result has really propelled litigation under this statute. One other case mentioned on the slide, Melvin versus Sequencing, that is a case from last August. A court granted certification in a federal class action brought under the GIPA or GIPA, alleging unauthorized disclosure of consumers' genetic information to unknown third-party developers of a website that sold DNA analysis reports. So that's an interesting decision as well, likely to propel some additional filings under the Illinois Genetic Information Privacy Act.
Jen, I think this is a good example where there's a hidden trap here for onboarding by employers in terms of giving the same form or using the same process for everyone. That's the kind of petri dish to grow a class action, where a statute like this says there are certain questions, certain inquiries that cannot be made. Those employers who do so subject themselves to liability under GIPA. And it's kind of a ready-made class action because it's the same onboarding process for everyone else. And so what we've begun to track now is other states getting into legislative updates of discrimination laws and thinking about instituting similar laws like this. So again, the watchwords are that patchwork quilt that's impacting both activities of companies as employers, as well as those that are providing goods and services through the internet or off their website to consumers. So in our last few minutes, we wanted to talk about what might be on the horizon and talk about some desk references we put together for use by companies. So if you took nothing else away from this presentation today, what you could expect are there going to be more class action filings. This is an area where the plaintiff's bar is viewing opportunity, a white hot area, laws being passed in various states and causes of action arising overnight. And then whenever there is a data breach, inevitably within hours, days, and less than weeks, you see the follow-on class actions brought for invasions of privacy. Kind of the next takeaway are the growing settlement numbers, and probably that has to do as much with social inflation and angry jurors and the kind of day in the life of plaintiffs now with nuclear verdicts and just the price of litigation inevitably rising. And so we've seen those numbers rise over the last 2 years, and our prediction would be they're going to rise equally, if not at a higher rate in calendar year 2024. And as more states enact more legislation and provide more causes of action, you're going to see more lawsuits that are going to lead to more settlement dollars. I think the other thing you're going to see, and Colin kind of underscored it in his tour of the world of all of the privacy cases that he has defended, that you're seeing the plaintiff's bar on the edge of the legal envelope, very innovative in their case theories, trying out new case theories, and when one don't work, move on and find another one. And so I think you're going to see innovative case theories that people never thought about in terms of bringing these large scale class actions throughout the United States. Next would be kind of that 14% figure that Jen talked about with certification of data breach cases. And I hearken back to 2011 when the US Supreme Court decided the seminal Rule 23 class action case known as Dukes versus Walmart. And for a period of about 3 years, the plaintiff's bar was blocked and had very, very low certification rates because the Walmart case had established new higher standards to certify a case. And yet within 5 years, and certainly now that a decade has passed, the plaintiff's bar rebooted, came up with new theories, and the certification rates began to rise. And now you're seeing certification rates close to 75%. And so you would expect that to occur not only in the data breach area, but also in the straight up breach of privacy area. So to assist our clients in this area, we have put together some desk references. One of them is a tour of the world, so to speak, with privacy class actions. Here's the code that you could download it. You could go on the Duane Morris website, download it also. It's also an ebook format. It's fully searchable. The price is right. It's absolutely free. We also have a guide on data breach and same sort of guide that enables companies to see what's out there. So we hope this hour-long tour of the class action world in the privacy space is helpful. Jen and Colin and I are available if you want to get on the phone or send us an email. And we thank you very much for your investment of 60 minutes to spend with us to get a tour of this space. So thanks so very much.